Looks like I'm stuck inside all day reading because it's just not that sunny outside. I had different plans for today, but it's safer on the inside. Offenses against the person. Section 7 of Criminal Law, BARBRI's Commercial Outline, on page 47. We have about 30 pages to go, and it's going to be through all of the substantive crimes, starting with the offenses against the person, number 1 being assault and battery. Battery is the unlawful application of force to the person of another, resulting in either bodily injury or an offensive touching. Simple battery is a misdemeanor. The state of mind is that specific intent is not required. A battery can be, but need not be, intentional. It is sufficient that the defendant cause the application of force with general intent, interpreted in most jurisdictions today as requiring no more than criminal negligence. Indirect application of force is sufficient. The force need not be applied directly. Thus, it is sufficient if the force is applied by a force or substance put in motion by the defendant. For example, battery may be committed by causing a dog to attack the victim or by causing the victim to take a poisonous substance. Aggravated battery. Most statutes define certain acts as aggravated. Aggregated batteries and punish them as felonies. Among the most common are batteries in which a deadly weapon is used. An ordinary object may become a deadly weapon depending on how it's used. 2, serious bodily injury is caused. Or 3, the victim is a child, woman, or police officer. Consent as a defense. Contrary to the general rule that consent of the victim is not a valid defense, some jurisdictions recognize consent as a defense to simple battery and or certain specified batteries. For example, a medical operation or reasonable injuries incurred in consensual athletic contests. Assault. 2. In a majority of jurisdictions, an assault is either an attempt to commit a battery or the intentional creation, other than by mere words, of a reasonable apprehension in the mind of the victim of imminent bodily harm. Are they going to give us the example? In a minority of jurisdictions, limit assault to the attempt to commit a battery. Simple assault is a misdemeanor. A. Present ability to succeed. Some statutes define assault as an unlawful attempt to commit a battery coupled with a present ability to succeed. Lack of an ability to succeed precludes liability under such statutes. A points a loaded gun at B. A pulls the trigger, thereby frightening B. Is A guilty of assault under the statute defining assault as an attempt to commit a battery coupled with the present ability to succeed? No, because the gun was unloaded. Sorry, I left that out. It was unloaded. A could not have succeeded in committing a battery. However, I still think that the intentional creation, other than by mere words, of a reasonable apprehension in the mind of the victim of imminent bodily harm is met, and this is a disjunctive rule, so I can't see why that would not be assault. Okay, but the question was with regards to battery. I understand that. Let's try that example again. Some statutes define assault. Some of them define assault as an unlawful attempt to commit a battery coupled with a present ability to succeed. So in those weird jurisdictions, I think California being one of them, lack of an ability to succeed precludes liability under such statutes, which means the unloaded gun scaring B is not going to present a liability of assault under statute defining assault as an attempt to commit a battery coupled with the present ability to succeed because the gun was unloaded and could not have succeeded in committing a battery. So, for every other jurisdiction that says that placing the victim in reasonable apprehension of imminent bodily harms, then I believe this would be considered an assault. So it's something very finite that you have to recognize between jurisdictions. Battery distinguished. So I really should have two note cards for assault. One being assault, and I'm just going to highlight it as an unlawful attempt to commit a battery. Element 1, coupled with, which is an and, it's not a disjunctive rule, coupled with the present ability to succeed. Whereas in most jurisdictions you have 1, an attempt to commit a battery, or the intentional creation, other than by mere words, of a reasonable apprehension in the mind of the victim of imminent bodily harm. Alright, so remember the distinction. Try to. Battery distinguish. If there has been an actual touching of the victim, a battery has been committed. If there has been no such touching, the act may or may not constitute an assault depending on the circumstances. See statutory aggravated assault. In all jurisdictions that treat certain aggravated assaults more severely than simple assault. Such aggravated assaults include but are not limited to assaults with a dangerous or deadly weapon or with an intent to rape, maim, or murder. Maim is another way to describe mayhem. Mayhem, under common law, the felony of mayhem either required dismemberment, removal of some body part, or disablement of a bodily part. The crime was enforced to preserve the king's rights to his subjects' military service. Modern statutes, most states retain the crime of mayhem in some form, although the recent trend is to abolish mayhem as a separate offense and to treat it instead as a form of aggravated battery. Modern statutes have expanded the scope of mayhem to include permanent disfigurement. A few states require a specific intent to maim or disfigure. Homicide. Classifications of homicides. Okay, justifiable homicides, those commanded or authorized by law. Excusable homicides for those which there was a defense to criminal liability. And criminal homicides are your 3 classifications of homicides. Common law criminal homicide. Murder. Murder is the unlawful killing of another human being with malice aforethought. Malice aforethought may be expressed or implied. Malice aforethought. 1. In the absence of facts excusing the homicide or reducing it to voluntary manslaughter, malice aforethought exists if the defendant has any of the following states of mind. Any of the following. So this is a conjunctive rule. Ruminant 1, intent to kill, which is express malice. Ruminant 2, intent to inflict great bodily injury. Ruminant 3, reckless indifference to an unjustifiably high risk to human life, which in parentheses is sometimes referred to as an abandoned and malignant heart. Or Roman numeral 4, intent to commit a felony murder, see infra, which we'll talk about, I'm sure, later. In the case of Romanet 2, 3, and 4, the malice is implied, whereas the intent to kill is where you see malice being expressed. Whereas implied is the intent to inflict great bodily injury and that person dies. Reckless indifference to an unjustifiably high risk to human life, including the abandoned and malignant heart expression of that element, and intent to commit a felony murder. Deadly weapon rule. Intentional use of a deadly weapon authorizes a permissible inference of intent to kill. A deadly weapon is any instrument, or in some limited cases, any part of the body used in a manner calculated or likely to produce death or serious bodily injury. Example, the following persons may be held guilty of murder under the deadly weapon rule: one who intentionally pilots a speedboat through a group of bathers, 2, one who fires a bullet into a crowded room, and 3, a professional boxer who beats up and kills a belligerent tavern owner. Voluntary manslaughter. Voluntary manslaughter is a killing that would otherwise be murder, but is distinguishable from murder by the existence of adequate provocation, i.e., killing in the heat of passion. Elements of adequate provocation. At common law, provocation would reduce a killing to voluntary manslaughter only if it met the following 4 tests. A, the provocation must have been one that would arouse sudden and intense passion in the mind of an ordinary person, such as to cause him to lose his self-control. B, the defendant must have in fact been provoked. C, there must not have been a sufficient time between the provocation and the killing for the passions of a reasonable person to cool. This is a factual question that depends upon the nature of the provocation and the attendant circumstances, including any earlier altercations between the defendant and the victim. And D, the defendant, in fact, did not cool off between the provocation and the killing. 2, when provocation is adequate. Adequate provocation is most frequently recognized in cases of being subjected to a serious battery or a threat of deadly force, and B, discovering one's spouse in bed with another person. 3, provocation inadequate as a matter of law. At common law, some provocations were defined as inadequate as a matter of law. The most significant was mere words. Modern courts tend to be more reluctant to take such cases from juries and are more likely to submit to a jury the question of whether mere words or similar matters constitute adequate provocation. Imperfect self-defense. Some states recognize an imperfect self-defense doctrine under which a murder may be reduced to manslaughter even though A, the defendant was at fault, B, the defendant unreasonably but honestly believed in the necessity of responding with deadly force. Involuntary manslaughter. C, involuntary manslaughter is of 2 types: criminal negligence and unlawful act manslaughter. A killing caused by an unlawful act is an involuntary manslaughter. There are 2 subcategories of such acts. But first, let's go into criminal negligence manslaughter. I almost forgot. If death is caused by criminal negligence or by recklessness under the Model Penal Code, the killing is involuntary manslaughter. Criminal negligence requires a greater deviation from the reasonable person standard than is required for civil liability. Some states also require that the defendant have had a subjective awareness of the risk. Unlawful act manslaughter. A killing caused by an unlawful act is involuntary manslaughter. There are two subcategories of such acts. Misdemeanor manslaughter rule is A, and B is felonies not included in the felony murder. Which, did we ever talk about felony murder? Okay, we're going to really soon. But let's first talk about misdemeanor manslaughter rule. A killing in the course of the commission of a misdemeanor is manslaughter, although most courts would require either that the manslaughter be malum in... malum in... This is all whack. Say, i.e. an inherently wrongful act, or in malum prohibitum, that the death be the foreseeable or natural consequence of the unlawful conduct. Okay, felony is not included in felony murder. If a killing was caused during the commission of a felony but does not disqualify as a felony murder case, does not qualify as a felony murder case, the killing will be at least involuntary manslaughter, and the death also must be foreseeable consequence of the felony. 3, statutory modification of common law classification. So 3 comes after 2, your common law criminal homicides, and after 1, which I suppose was assault. I think. It might not be. 1 was classifications of homicides. My fault. We're still in homicide. 3, statutory modification of common law classification. Modern statutes often divide murder into degrees, and the bar examination often contains questions based on statutes similar to them. Under such schemes, all murders are second-degree murders, similar to common law murder, unless the prosecution proves any of the following, which would make the murder first-degree murder. Which is an interesting way to look at it, because it's not usually looked at that way. It's usually looked at as murder is inexcusable unless there's defense, and then you work your way down. But in this case, in the BARBRI outline, we're going to talk about, we've talked about everything that isn't a felony murder, and now we're going to talk about felony murder. I'm sorry, we're going to talk about looking at murder as that which is now constitutes first degree. So, A, deliberate and premeditated killing. Deliberate means that the defendant made a decision to kill in a cool and dispassionate manner. Premeditated means that the defendant actually reflected on the idea of killing, if only for a brief period. First degree felony murder. B, under 3, statutory modification of common law classification. First degree felony murder. Many state statutes list specific felonies that may serve as the basis for felony murder. Fucking hair always looks like shit. If a killing is committed during the commission of one of these enumerated felonies, the killing is usually first-degree murder without the prosecution needing to show that the killing was either deliberate or premeditated. The felonies most commonly listed are burglary, arson, rape, robbery, and kidnapping. But other felonies that are inherently dangerous to human life are often specifically added. Second-degree felony murder. Okay, again, burglary, arson, rape, robbery, and kidnapping. But other felonies are inherently dangerous to human life, which we've talked about is like bombing and driving into a crowd, or those come off the top of mine. Burglary, arson, rape, robbery, and kidnapping are the ones listed here. First degree felony murder. Many of the state statutes list specific second degree felony murder. 2. Within the first degree felony murder section, we have, even if the state lists the felonies to be included under the doctrine, a separate statute or case may provide for criminal liability for killing committed during the course of a felony that is not listed. Such killings typically will be classified as second-degree murder. Other state variations, too, under the first-degree felony murder section. Some states may not list the felonies to be included under the felony murder doctrine at all. Other states that permit felony murder liability based on a felony that is not listed sometimes include the additional requirement that the felony be inherently dangerous to human life, or that the felony be dangerous to human life as committed. Some state statutes make killings performed in certain ways first-degree murder. Thus, killing by lying in wait, poison, and torture may be first-degree murder. Yeah, that's okay. Those are the ones that are missing. So, sometimes it seems like this book, or this outline and the book are like, and what we learn in class are hard to tie together. So we try synthesis as best we can. Felony murder and related matters. Definition of malice aforethought above makes clear a killing, even an accidental one, committed during the course of a felony is murder. Malice is implied from the intent to commit the underlying felony. Got it. Can we please move on? I can't stand this topic. What felonies are included? Sounds like we already talked about it, but let's go for it again. Under the common law, there were only a handful of felonies. Today, the criminal codes of states have created many more. Fantastic. Scope of the doctrine. B. When the felony murder doctrine is combined with conspiracy law, the scope of liability becomes very broad. If in the course of a conspiracy to commit a felony a death is caused, all members of the conspiracy are liable for murder if the death was caused in furtherance of the conspiracy and was a foreseeable consequence of the conspiracy. If I didn't write this concept well enough in conspiracy, I'm underlining it here, but this is pretty basic. C. Limitations on liability. There are some limitations on liability under the broad felony murder doctrine. Commission of underlying felony. 1. To convict a defendant of felony murder, the prosecution must prove that he committed or attempted to commit the underlying felony. Thus, if the defendant has a substantive defense that negates an element of the underlying felony, he has a defense to felony murder. However, procedural defenses such as a statute of limitations defense to the underlying felony will not be a defense to felony murder in most states. Limitations on liability. 2. Felony must be independent of killing. The felony murder rule can be applied only where the underlying felony is independent of the killing. Thus, a felony such as manslaughter or aggravated battery will not qualify as an underlying felony for purposes of felony murder liability. Why? Because of what were we saying that was called double, I want to say jeopardy, but I don't think that's right. Basically, you're not going to be, you're not going to combine, you're not going to merge those two. Okay, so this might be a concept of merger, and I'm going to write that here. Can't be convicted for the same crime. You can't be convicted for death for a homicide and also for, a battery, because it's just a higher degree offense of the other. In Erica words. 4. During the commission of a felony, termination of felony. So this is 4 under the limitations on liability. The death must have been caused during the commission or attempted commission of the felony, but the fact that the felony was technically completed before death was caused does not prevent the killing from being felony murder. Deaths caused while fleeing the crime are felony murder. But once the felon has reached a place of temporary safety, the impact of the felony murder rule ceases, and deaths subsequently caused are not felony murder. What is the term for that, and why aren't they providing it? Starts with a C. Killing of co-felon by victims of felonies or pursuing police officers. Is the defendant liable for a co-felon's death caused by a resistance of the victim or police? The majority view is no. The so-called red line view, the majority position, is that liability for murder cannot be based upon the death of a co-felon from resistance by the victim or police pursuit. Okay, and just to fix where the outline is falling short, clear and convincing evidence is a standard of proof, 75% standard of proof. Preponderance of evidence is 51%. And beyond a reasonable doubt is higher. Did I say preponderance of evidence? Yeah. Preponderance of evidence. Okay. Still looking for not concurrence. Never going to find it. There is a word for when for what we just described. I'm not going to find it right now, but I'm not even so sure if I'm going to find the page where it was on. The commission of a felony, right? There's a word for continuation of the felony. Such that a murder that occurs during the part of the felony when the felon is fleeing from the crime is so close to the murder that the felony murder rule takes over. And I don't have the word for that. Maybe one day we'll figure that out. So compare killing of innocent party by victim or police. The agency theory of felony murder provides that for a felon to be held liable for felony murder, the killing must have been committed by the felon or his agent, which is the accomplice. Thus, if a bystander is accidentally killed by a police officer during a shootout at a crime scene, there would be no felony murder liability because a police officer caused the bystander's death. There are limited exceptions in cases in which the victim was used as a shield or otherwise forced by the felon to occupy a dangerous place. Under the proximate cause theory, felons are liable for the deaths of innocent victims caused by someone other than a co-felon, since they put into operation a series of events that caused the death of the innocent party. Related limits on misdemeanor manslaughter. D. D of what? D of felony murder. 4. Limits similar to those placed on felony murder are placed on involuntary misdemeanor manslaughter. If the misdemeanor involved is not malum in se, i.e. one that involves conduct that is inherently wrong, a death caused during the commission of the misdemeanor is manslaughter only if death was a foreseeable result of the commission of the misdemeanor. A minority of courts limit the doctrine to malum in se misdemeanors. Example, K is driving on a good road in excellent weather but is slightly exceeding the posted speed limit. V dashes from behind a bush into the street and is struck by K's car. V dies. Is K guilty of involuntary manslaughter, assuming that speeding is a misdemeanor? The best answer is no, because the misdemeanor was not malum in se and death was not a foreseeable result of its commission. Causation. I'm going to comment on that. But causation is 5. So we're no longer in 4, which is the awful, hard to describe felony murder. Or at least it's just hard to describe in this fashion because it wasn't complicated until we started reading the BARBRI outline. Right. Causation. General requirement must be cause and fact and proximate cause. When a crime is defined to require not merely conduct but also a specified result of that conduct, the defendant's conduct must be both the cause and fact and the proximate cause of the specified death. 1. Cause and fact. The defendant's conduct must be the cause and fact of the result. Example, the result would not have occurred but for the defendant's conduct. Common law requirement, year and a day rule. I have this written down. The death of the victim must occur within 1 year and 1 day of the infliction of the injury or wound. If it does not occur within this period of time, there can be no prosecution for homicide, even if it can be shown that but for the defendant's actions, the victim would not have died, and when he did. The rule has been sharply criticized by the United States Supreme Court as an outdated relic of the common law, and most of the states that have reviewed the rule have abolished it. C4, page 54, proximate causation. 3 under the general requirement for causation, because 1 and 2 is cause and fact and the other is the year and the day rule. So here's the proximate causation. Problems of proximate causation arise only when the victim's death occurs because of the defendant's acts, but in a manner not intended or anticipated by the defendant. The question in such cases is whether the difference in the way death was intended or anticipated and the way in which it actually occurred breaks the chain of proximate cause causation. A. All natural and probable results are proximately caused. The general rule is that a defendant is and probable consequence of his conduct, even if he did not anticipate the precise manner in which they would occur. All such results are proximately caused by the defendant's act. This chain of proximate causation is broken only by the intervention of a superseding factor. B. Rules of causation. 1. Hastening inevitable result. An act that hastens an inevitable result is nevertheless a legal cause of that result. A terminates the life support system of B, resulting in B's death. B had only 24 hours to live. Can A be held liable for B's death? Yes. Note that society may not wish to condemn such an act of mercy. Nevertheless, the purposes of causation analysis, A's act caused B's death. We're reading B, rules of causation. Number 2, simultaneous acts, and number 3, pre-existing conditions. So, for simultaneous acts by two or more persons may be considered independently sufficient causes of a single result. And 3, pre-existing condition. A victim's pre-existing condition that makes him more susceptible to death does not break the chain of causation. For example, the defendant takes the victim as he finds him. For example, A, with malice aforethought, shoots B in the leg. B bleeds to death before he can receive medical attention because he is a hemophiliac. A is responsible for murder despite the fact that a person without hemophilia would not have died from the shooting. C, intervening acts. I actually wonder if shooting someone in the leg would be considered deadly force as a defense, as an affirmative defense, unless there's a pre-existing condition such as this, or if it would be considered non-deadly force if there wasn't a pre-existing condition such as this. Good question. Never going to be answered. Intervening acts. As a general rule, an intervening act will shield the defendant from liability if the act is a mere coincidence or is outside the foreseeable sphere of risk created by a defendant's act. Acts of nature, an act of third party, and act of the victim is going to be discussed within the intervening acts. Section C under causation. Because we've already read the general requirement must be cause and fact and proximate cause for causation. And we've already read the rules of causation, hastening inevitable result, simultaneous acts, and pre-existing condition. And now we're talking about intervening acts. C. As a general rule, an intervening act will shield the defendant from liability if the act is a mere coincidence or is outside the foreseeable sphere of risk created by the defendant's acts. For example, an act of nature is driving negligently. To avoid A's swerving car, B takes an unaccustomed route home. B's car is struck by lightning and B dies. Can A be charged with manslaughter? No. The fact that lightning struck B is a mere coincidence. And 2, act by third party. A, intending to kill B, merely wounds him. B receives negligent medical treatment at a nearby hospital. B dies. Can A be held liable for B's death? Yes. Despite improvements in medical care, negligent care remains a foreseeable risk. A contrary result would follow if B died due to gross negligence or intentional mistreatment. So I feel like this is different than maybe the common law, or what I recall from the book, just period. So I will want to look at this section, the cases in this section. Because I do recall, the poor care being the cause of the death in some of our cases. But again, that could be gross negligence or intentional mistreatment, just under another name. So might want to shore that up by rereading that section. Acts by the victim. A, intending to kill B, merely wounds him. B B refuses medical treatment for religious reasons and dies. If modern medical knowledge could have saved B, can A be held liable for B's death? Most jurisdictions have held yes because A's act directly created the risk of death and because the refusal of medical care may be found to be foreseeable. This rule may apply even if the victim acts affirmatively to harm himself. Suppose B, in unbearable pain, commits suicide. The suicide may be found to be a foreseeable consequence of A's actions, thus A would be liable for B's death. Again, this is a little bit different than I recall reading it. 6, born alive rule, and 7, summary analytical approach. So these numbers may conclude our discussion of homicide, thank God. Born alive rule. Traditionally, an infant had to be born alive to be a victim of a homicide crime, meaning that the infant must be completely expelled from his mother and show independent signs of vitality. A number of states have abrogated this rule by statute by extending protection to unborn children as potential victims of homicide crimes. And 7, summary analytical approach. If analyzing any homicide situation, the following questions must be asked and answered. A, did the defendant have any of the states of mind sufficient to constitute malice aforethought? B, if the answer to A is yes, is there proof of anything that will, under any applicable statute, raise the homicide to first-degree murder? This is just not how we were looking at it in class. We were looking at it the other way around. Is there malice aforethought? Is there a defense? In this case, it's not, is there a defense? There is. Is there proof of anything that will, under the applicable statute, raise the homicide to first-degree murder? If the answer is yes, is there evidence to reduce the killing to voluntary manslaughter, i.e. adequate provocation? If the answer to A is no, and we're talking strictly A. Okay, so is there a state of mind sufficient to constitute malice aforethought? If yes, is there any proof that will raise the homicide to first-degree murder? The second question you'll ask, if there is malice aforethought, is there any evidence to reduce the killing to voluntary manslaughter? If malice aforethought is not found, is there a sufficient basis for holding the crime to be involuntary manslaughter, for example, criminal negligence or misdemeanor manslaughter? E, is there adequate causation between the defendant's acts and the victim's death? Was the defendant's act the factual cause of death? Is there anything to break the chain of proximate causation between the defendant's act and the victim's death? Example, A came upon B, who was letting the air out of a tire on A's car. When A shouted at B, B picked up a rock and threw it at A, shouting obscenities. B ran off, but A went into his car, pulled a gun out, and shot at B, hitting him in the leg. B was taken to the hospital where he underwent surgery. The wrong gas was used as an anesthetic and B died. Generally, wounds of this sort are not deadly. A testified under oath that he merely intended to wound B as revenge for causing A the inconvenience of a flat tire. What is A's liability? 1. Even if A intended only to wound B with a bullet, it is intent to inflict great bodily injury and is sufficient for malice aforethought. 2. If the statute makes premeditated killings first-degree murder, A almost certainly did not premeditate. And 3. While B's shouted obscenities might not be adequate provocation, a jury could certainly find that throwing the rock was such provocation. 4. If the answer to the inquiry A had been no, and for instance, the question was, is there sufficient evidence to prove malice aforethought? If there wasn't, A's actions would have constituted criminal negligence. Yeah. And 5, there is a causation, but for A's shot B would not have died. Negligent medical care is not a superseding intervening factor that will break the chain of proximate causation unless it is gross negligence or intentional malpractice. And it's right there that I'm confused, because it says in the facts that generally wounds of this sort are not deadly. However, I suppose you need to seek treatment, and the treatment caused death. So I'm calling this as being in conflict with the book and with itself. But because there is causation, it says. But for a shot, B would not have died. No, but for a shot, it says right here, it was not a deadly wound. And B would not have died because the wound was not deadly. Negligent medical care is not a superseding intervening factor that would break the chain of proximate causation, except I believe that it was, because it wasn't a deadly wound. And so we saw this in our cases in the second semester. And so I'm going to return to this. False imprisonment B is another, letter B. Letter C, homicide, we're going to close the book on that, or we're just going to stop discussing that. B was mayhem and A was assault and battery. So now we're moving into false imprisonment. Afterwards, E, kidnapping, before we enter into the sex offenses. So, false imprisonment. The common law misdemeanor of false imprisonment consisted of Romanet 1, unlawful, Romanet 2, confinement of a person, Romanet 3, without his valid consent. Let me tell you, it has been really hard to find the definition of this crime. So, I'm going to have to add that baby to my note cards. Right here. Confinement. Confinement requires that the victim be compelled either to go where he does not wish to go or to remain where he does not wish to remain. It is not confinement to simply prevent a person from going where he desires to go, as long as alternative routes are available to him. The confinement may be accomplished by actual force, by threats, or by show of force. The MPC takes a similar approach in that the confinement must interfere substantially with the victim's liberty. Unlawfulness. Confinement is unlawful unless it is specifically authorized by law or by the consent of the person. If somebody says, "Don't let me eat that donut," right? Can you lock them in their bedroom? Is consented by the person? At one point, I don't think so. But if somebody has broken into your kitchen to steal your donuts, can you lock them in the kitchen until the authorities come? Probably. And 3, lack of consent. Okay, or authorized by law is in if somebody got in trouble for burglarizing my house of my donuts and then is sent to prison, therefore, for like 7 years or something. Confinement authorized by law would be that applicable to prison guards, keeping them in prison. Okay, lack of consent. Consent to the confinement precludes it from constituting false imprisonment, but the consent must be freely given by one with capacity to give such consent. Thus, consent is invalidated by coercion, threats, deception, or incapacity due to mental illness, substantial cognitive impairment, or youth. So it's never okay to lock a kid in their bedroom, even if they say to do it so that they avoid eating donuts, because they're a youth. Kidnapping. Letter E. At common law, the misdemeanor of kidnapping was the forcible abduction or stealing away of a person from his own country and sending him into another. Modern statutes of the MPC generally expand the definition of kidnapping far beyond the common law definition, although it usually remains a form of aggravated false imprisonment. General pattern. Kidnapping is often defined as confinement of a person that involves either A, some movement, i.e. aspiration, of the victim, or B, concealment of the victim in a secret place. 2. Aggravated kidnapping. Modern statutes often contain as a separate offense an aggravated kidnapping crime. Among the more common forms of this offense are kidnapping for ransom, kidnapping for purpose of commission of other crimes, kidnapping for offensive purpose, or child stealing. So, A, kidnapping for ransom. The abduction of the abduction for secretion of a person for the purpose of obtaining anything of value for the return of the person is often defined as aggravated kidnapping. B. Kidnapping for purpose of commission of other crimes. Abduction or secretion for the purpose of committing other offenses such as robbery is sometimes defined as aggravated kidnapping. C. Kidnapping for offensive purposes. Abduction or secretion, 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 with the intent, secretion, of the intent of harming the person or of committing some sexual crime with him, is sometimes defined as aggravated kidnapping. And D. Child stealing. Leading, taking, enticing, or detaining a child with the intent to keep or conceal the child from a guardian or parent is often defined as aggravated kidnapping. Use of enticement covers the situation in which a child is persuaded by promises or rewards to come with the defendant or remain. The consent of a child to his detention or movement is not of importance because the child is incapacitated by age from giving valid consent. 3. Required movement. 4. Secrecy. 5. Consent. 6. Relationship to other offenses. All have to be discussed before we can finish section 7. Required movement. 3. Although at common law extreme movement was required, most modern statutes require only some movement of the person. If such movement occurs, the extent of the movement is not material. Other statutes require no movement, making confinement, as used in false imprisonment, sufficient. Right. So, the reason why they're discussing movement here is because it was supposed to be movement out of beyond state lines, right? Stealing away a person from his own country and sending him into another was the movement under common law that was required. And now we're saying the least of movement or no movement at all is sufficient. Secrecy. Generally, it is not necessary that kidnapping involves secrecy. Some statutes, however, require secrecy when the kidnapping is based on confinement rather than movement of the victim. And 5. Consent. As with false imprisonment, free consent given by a person competent to give it precludes the confinement or movement of a person from being kidnapping. But a person may be incompetent to give such consent by reason of age, see above, or mental condition. So, if mom with a mental condition says, you can keep my kid, that's not really consent. So, as with false imprisonment, reading this again, free consent given by a person competent to give it precludes the confinement or movement of a person from being kidnapping. But a person may be incompetent to give such consent by reason of age, as in grandmother, whose great-grandmother is taking care of the baby, or mental condition. Relationship to other offenses. Statutes that define kidnapping as detention involving movement of the victim mean that it is arguable that kidnapping often occurs incident to the commission of other crimes such as robbery or rape. Some courts, but not all, have held that in such situations kidnapping, in addition to the robbery or rape, is committed only if the movement of the victim substantially increases the risk to the victim over and above that necessarily involved in the other crime. If no such increased risk is involved, the defendant will be held to have committed only the robbery or rape. Okay, Section 8, sex offenses, is coming up next. If I can bear to read it. Generally, one would expect that this would not be part of the bar exam, because for those persons that have been victims of sex offenses, this would not be appropriate for them to be tested upon for reasons of traumatic stress. So, can I skip it? Would love to. But every single question seems to have to do with statutory rape because of consent not being defense and mistake as to age. So maybe I'll just read that section there. Statutory rape is the crime of carnal knowledge of a person under the age of consent. Even if the victim willingly participated, the offense is nevertheless committed because consent is irrelevant. So there you go. That's kind of the definition of rape. Unlawful carnal knowledge of a woman by a man, not her husband, without her effective consent. Statutory rape, crime of carnal knowledge of a person under the age of consent, even if the victim willingly participated, because consent is irrelevant. The age of consent varies from state to state, generally from 16 to 18. Now, mistake as to age. Will a defendant's reasonable mistake as to the victim's age prevent liability for statutory rape? For purposes of the examination, the best answer is no, since statutory rape is a strict liability crime. Remember that. A second best answer, to be used only if no alternative making use of the best position is presented, is that a reasonable mistake as to age will prevent conviction if the defendant reasonably believed the victim was old enough to give an effective consent. Other topics of conversation in sex offenses is, well, we have a lot in consent. Penetration is sufficient. Rape requires only the penetration of a female sex organ by a male sex organ. Admission is not necessary to complete the crime. Today, a number of states rename rape as sexual assault and have made such statutes gender neutral. Okay, so a lot of things have developed here. I want to highlight that in a different color, but the absence of marital relationship. The woman must not have been married to a man who committed the act. However, today most states have either dropped this requirement where the parties are estranged or separated, or abolished in entirety. Lack of effective consent. The intercourse must be without the victim's effective consent. Consent, if given, may be ineffective in several situations. Intercourse accomplished by force, intercourse accomplished by threats, victim incapable of consenting, consent obtained by fraud. Only in limited circumstances will intercourse with consent obtained by fraud constitute rape. That's fraud as to whether act constitutes sexual intercourse. If a victim is fraudulently caused to believe that the act is not sexual intercourse and the act of intercourse constitutes rape. Example, B persuaded V that what was actually an act of intercourse was medical treatment accomplished by surgical instruments. Was B guilty of rape? Yes. Fraud as to whether defendant is victim's husband. If defendant fraudulently persuades the victim that he is her husband, is the intercourse rape? The best answer is no. B arranges for X to pretend to marry D and V. In fact, X has no authority to marry persons, and there is no marriage. After the sham marriage, D has intercourse with V. Is D guilty of rape? The best answer is no, because there was consent. Right. Other fraud. Other kinds of fraud will not make the intercourse rape. So D promises to marry V at a later time and thereby induces V to consent to intercourse. D never intended to marry V. Is D guilty of rape? No.